Buying a home? Don't panic. Just listen to the rest of this podcast. All right, everybody, welcome back to another episode of Home Inspection Authority's Straight Talk Podcast with me, John Laforme. I'm a CREIA certified home inspector from Los Angeles, California, and the topics we discuss on this podcast are about buying homes, selling homes, inspecting homes. So if you're a home inspector, home buyer, real estate professional, this podcast is definitely for you. All right, so my guest today is Greg Pyfrom, attorney at law. Hi, Greg.
Hey, how you doing?
I'm good. Welcome to the studio.
I like it.
You like it?
Yeah.
Does it set the mode right?
It certainly does. This is kind of like when we were on national TV on Case.
Oh, nice.
Yeah, it's a flashback. It's really good.
A flashback. So, Greg, tell everybody about yourself, who you are, how long you've been an attorney, and what kind of attorney you are.
I'm a trial lawyer. I was an actor who couldn't make it, and I love being on stage. So
really?
Acting is very much like being a trial lawyer, and there's no better stage than in front of a jury. It's just having a good time, and you get to be basically the producer, the director, the actor, and if you don't like the script in the middle of the script, you just change it. It's just fun, and if if you question certain things, question them vigorously and act to the jury and let them know who you are and how passionate you are about something. I mean, I could probably sell almost anything. So it really is fun. It really is.
That's great to hear because, you know, if you love what you're doing, it's not really work. It's
work. And you have to deal with lawyers, and that's not the fun part of the job.
No, not if someone's bringing a case against you. Then you got to defend yourself, and defending yourself is part of risk management, which is a huge thing in the home inspection business. So that's where you come in to help out. So now fill everybody in on how long you've been doing this.
I've been doing this 45 years, and I was trying cases in front of a jury and a judge before I even became a lawyer. We had a program that allowed you to have a mentor, and you would go to court and you would do the small little things, small claims for someone when they're there, or you do a hearing. And I just liked it. I mean, it was really easy. And telling you one quick story is that I was actually trying cases. I worked for a lawyer who sometimes, because he was Irish, hit the bottle a little more than he should. And he wouldn't show up at court. So I would be there, and after a while, the judges knew me so well and that I had done so many things before them, they would ask, well, where is your mentor? And I said, I'm sure he's in court, probably in another courtroom. and he would look at me and smile and go, this is a minor matter. You can just go ahead and try the case. So I was trying cases before I ever became a lawyer in court.
Wow.
It was.
And that's legal?
Well, I'm sure it pressed the outside of the envelope, but the client didn't mind. And it'd be basically something minor like somebody had a violation of something at their house, or there would be something like a moving violation.
So no murder cases?
Oh, of course not. Of course not. Okay. And certainly nothing of high value.
Right.
And these judges had so many of them, they just wanted them off the books. So they kind of winked and, and when I got a little bit too much, they kind of said, let's approach the bench. And they'd say, Greg, you're pushing the outside of the limit.
Yeah, you're walking the line, son.
Yeah.
Well, I never heard this from you before, so this is interesting for me to hear this right now. That's a good story.
So
I like it.
I decided when I passed the bar, I could have gotten various jobs because I used to be a tennis pro. So I was playing tennis with junior partners and so forth. So I got this entertainment to go to this intercession, I would say, about going in and getting a job. The junior partners would bring me in because they wanted to play tennis. So I would play tennis with them. And so during breaks, they would have me right there and they could sneak away for a set or so.
Rubbing tennis elbows.
Oh, yes. Yeah. Or tennis balls.
Yeah.
Anyway, to make the long story short, is that I decided that if I took a job paying more money, I would get almost no experience. So I went to a house counsel, and the senior partner of that one was a big tennis guy that I'd been playing for years with. And I started at $12,500 for house counsel, and that would be in 1976.
Let's see. Oh, hang on. What was I doing in 1976? 1976? I was 10 years old. I was born in 66.
Right.
I was born in 6. I was 10 years old.
Anyway, nobody wanted to try cases. So I only wanted to try cases. So I would trade vacation days for their trials they didn't want anyway. So normally by the third year, you may get second chair or something. Well, by the end of the first year, I had tried more cases than anybody in the firm.
Oh, wow.
So I loved it. It was theater.
Right.
And I just make up stories and I just say, I don't believe anyone believes their story. And I go to the jury and I look right at them and said, you can't believe this. Who would believe this? And I would win. So it just became addictive. And then by accident, and again, I fell into the home inspection industry, having tried a couple of cases on national TV. And I was representing pharmaceutical companies and Fortune 500. We did the 64 plaintiff salmonella case with a $37 million demand that we defensed. And at the same time, I was introduced to the home inspection industry by one of the former individuals who actually started CREIA. His name was Jim Farmer and Alex Kaczynski. And I got in it by accident. I was building a house. And of course, I had built homes for years. And of course, I knew everything about construction. And I had this Jim Farmer guy, this older guy, tell me that I didn't know what I was talking about. And of course, I took umbrage to it. I got upset and I got in his face and he said, look, this basically heating air conditioning system that you've put in, I know you bought it at a discount, but it's going to be right outside your 3-year-old daughter's bedroom, isn't it? I said, yes. He said, it's been recalled for CO2.
Oh.
My daughter is alive. Mm-hmm. She's a lawyer in San Diego.
Right on.
And she's a terrorist. I'm telling you, absolutely a terrorist. She disowns me. So all I can tell you is from that point forward, all I wanted to do was home inspection. So I got involved with it.
Right.
And the truth of the matter is that I've recreated this monster. And now we have to recreate it again. So that's kind of the history. I have tried.
That's very interesting.
I've tried to verdict in excess of 200 Superior Court jury trials, including 3 on national TV. And as it relates to home inspection cases, I probably handled more than.
You mean, when you say in national TV, you're meaning like there's cameras in the courtroom and it's just televised. Is that what you're saying?
Yes. I'm giving you, for instance, you have a credit card, or you have a Vons card, or you have a Ralph's card.
Right.
We tried the right of privacy case on that very issue of whether or not for example, a supermarket gets particular information which should be held in privacy. And it was used against a plaintiff who slipped and fell at that market. And in this case, that didn't happen. The guy was buying 5 quarts of tequila for his self-use, and he slipped and fell in the market, and he had been using that type of alcohol for a long time. And he was drunk at the time, and we had witnesses say he was drunk, and we got the information about the 5 quarts of tequila from him in deposition. Huh. So that we got a non-suit, which means at the end of the plaintiff's case, you argue to the judge that they haven't met their burden of proof, and the judge grants it. We also did the eye-out case, and the eye-out case is a very famous case out of Mirage Hotel in Las Vegas, where they had 3 parties at a pie gow table at 2:30 in the morning, and one of them allegedly is a Taiwanese mafia. One guy in the center was a guy from LA that is also Taiwanese, and the person dealing the cards was Taiwanese. And then they had the guy whose son was present. And the guy's son in question had built every high-rise building in Taipei, Taiwan, and was flown over by Mirage. And to make the long story short, in the middle of the Pai Gao game, the alleged Taiwanese mafia guy had won 8 times in a row, $25,000 a hand. And the young kid, and I say young kid, he was in his early 30s, leaned over and said, "Are you going to live forever?" Meaning, are you going to keep winning? The Taiwanese guy got very upset. "You're trying to jinx me. I'm superstitious." And the alleged Taiwanese mafia guy got upset when he lost, leaned across the table and took out the gentleman's right eye out of his socket and put it on the table. I was brought in to try that case in downtown Los Angeles. And I also got a non-suit at the end of the case, meaning...
So one guy took out the other guy's eye?
And put it on the table.
Well, how did he do it? With his hand?
With his finger.
Wow.
So, I mean...
Wow, that is a crazy story.
I had another case in which had to do with pharmaceutical where a guy had a bad liver, and we admitted we gave him the wrong medication. And I proved that what really occurred was his physician committed medical malpractice, and we defensed the case to a jury in Ventura.
Wow.
I actually was the trial lawyer of the month in California for that one case in November of 1994. And you can only win it once in your career.
Wow. Congrats, man. Did you bring your plaque?
No, but I have it.
All right. That's awesome. That's a great story. Wow. The old finger gouge and takes out an eyeball and leaves it there.
Puts it right on the table. And the
guy go into shock, pass out. I mean, what happened?
I don't know what happened to him.
The listeners want to know what happened next.
Well, I can tell you that the mafia guy or whoever he was somehow got to the airport, McLaren, somehow got out of the aircraft space of the United States before the police came, figured out who he was, and looked for him.
Oh, wow. Connected man.
There's a rumor that's true.
There's a rumor that's true.
Yes. That's a rumor.
That's a rumor. Okay, got it. All right, let's change some gears here, and let's get into that boring thing called home inspections and risk management. So I have a few questions for you, only because when I started out doing this, I didn't know who to go to ask questions, except for another attorney I've always used for other businesses in the past, but who has no experience doing this type of work. So I'm hoping that you can kind of fill in the blanks for anybody new starting out to get into the home inspection business, whether they're going to work for a multi-firm or whether they're going to start their own business. So a couple questions I had was exactly what steps need to be taken for just an individual to just start a home inspection business. What's the first thing he needs to do? Or she nowadays. There's a lot of women getting in the business.
Get the education.
Okay.
You need to know what you're doing. Like anything, if you want to be a professional, get the training of a professional, do the pre-inspection outlines that are necessary. Make sure that you have the contract that is going to protect you. Make sure you have the insurance coverage. But more than anything else, have a plan. Know what you need to know. Know what you don't need to know. But make sure all the ingredients you need. It's like baking a cake. If you leave out the sugar, you leave out the flour, it's not going to work out.
Right. It's not going to work out. That's a good point. And you did mention contracts. So we are going to get into that a little more in depth here. So basically, getting educated to a a certain extent before you open up your business. That is great advice. That's the same advice I would give somebody. If you have no experience whatsoever in the trades of maybe framing or plumbing or heating and cooling or foundations, if you just don't know how a house is put together, you need to do a lot of training on that, because that is going to be something you're dealing with every day. And you need to know how to answer questions and troubleshoot things before you open your mouth and say the wrong thing to the customer, because you're just inexperienced. So that was a really good point right there. As far as if I want to start a business now, home inspection business, do you think I need to do a LLC, an S corp, a C corp? Do you have any advice on that?
It depends on who you are,
right,
what you own, how you're directing your business. If you're already going in with someone else, follow their lead. And the reason for it is learn from them. You will learn more by experience and find out what people are doing right and what people are doing wrong if you just ask the right question and listen. You
Right.
will learn more by listening than talking. It's always the rule.
Okay. All right, you listen right now. I'm going to do some talking. All right. Good point. All right, so it depends on, do you have a lot of assets, is what you're saying.
Correct.
To break that down, if you already have a lot of assets, maybe you own some property, or maybe the house you live in, you own, you want to keep that separate from your business in case the event you do get a claim and someone tries to sue you and so forth. So about right?
Yes, make sure that you do have, though, a corporate standing versus as an individual, and that's the point you really made.
Yeah.
Is that the more you do it as a person, the more your assets are open. The more you deal it as a business with the IRS notified, with all the steps necessary to be a business, which is really very easy.
Which requires a federal ID number.
Sure. And the state of California has a list of all the things you have to do. Call the state of California. Call your local business community. Be a member of the business community. Follow their guidelines, and you will find protections.
Right. Run your business like a business. That's what Greg's definitely pointing out there. So starting off from the ground up, with everything in place as far as your tax information, all that stuff, it's worth it in the long run, guys. It's worth it. And when I was really young, I started a business. Here's a little side story for you. You'll get a kick out of this. I started building houses and working in the trades at a very young age. I was probably 16, 17, when my uncle used to take me and have me changing doorknobs and stuff, and just minor stuff. And then over the years, I got more and more into it, and I started doing bigger and better things. And basically what I wound up doing soon after, I started working for this big construction company just as a framer. And this guy taught me a lot. And I worked with him for 2 or 3 years. And he taught me how to read blueprints and all that stuff. And then towards the building boom, when it started declining, when I started out, there was a lot of building, and that was bad. That was in 80, 85, 86. There was a lot of building going on the East Coast. And then, after 5 or 6 years, it started declining. And then when we started losing the big jobs, a lot of the older guys, remember, I was really young, and I let all these older guys, 40s, 50s, 60 years old, still banging nails and being carpenters. They're like, you know a lot. You should go start your own business. So they kind of nudged me. I was like, I don't know about that. So I tried it. And I got business. I got job after job after job. No problem at all. However, I had no clue how to run a business. I was bouncing checks all over town. I had to get my sister involved, and it was hilarious there. She goes, John, you owe more in bounce check fees than you have money in the bank. It was crazy. So I had no business experience. I had zero. All the guys at work never told me about that part. They just said, you should do this on your own, and I tried it, and I was very successful for a while. I had no problem getting the work. I knew how to do the job. I was really good at framing homes and adding additions to homes and building custom decks. I was really good at that. But when it came to business, nope, no training whatsoever. Balancing the checkbook, it was a mess. So eventually, building and the economy just went really low, and it all just kind of fell apart. So that was my wake-up call for life, for the rest of my life after that, knowing, well, if I'm going to do a business, I need to know how to do certain things. And I just got smarter from that. So it was good to fall on my face at that early age, because I was able to recover later and just be successful in other things over the years, you know? So it was pretty cool.
Heard that story before.
You have, right? Probably from your own kids?
No.
Not your own kids. All right. So going back to what I was getting at with, the startup and all that, basically there is going to be an inspection agreement or a inspection contract. Can you specify what the difference is there?
What you're talking about is a contract. People say inspection agreement. You can have an agreement to go to the drugstore and pick up a product. That's not a contract.
See.
So the difference is an agreement can be an agreement and it can be a contract. But a contract can only be a contract. And a contract is a legal document which sets forth a duty, breach of duty, and in essence, an offer, acceptance, and consideration. And we're going to be talking about a home inspection contract and that issue in relation to very high-level defenses, which I have built into the CREIA contract.
Right. And you mentioned duties. I like how you mentioned duties. And the client has a duty, don't they?
Both sides. A contract is bilateral, right, meaning both sides have duties, obligations, and conditions.
Right. So I'm going to touch on client's duty because years ago you recommended I have that in my contract. So I do have it in there. Client agrees to read the entire written report when it is received and promptly call inspector with any questions or concerns regarding the inspection or the written report. The written report should be the final and exclusive findings of the inspector. I don't think most people signing contracts are aware that they have a duty also. It's not just us doing something. They need to act.
There are conditions in every contract. There are duties in every contract. That's why it's called bilateral, meaning both sides. Mm-hmm. Understand that you are not the individual who basically makes sure that the client is okay. The client is the person who has the duty to make that client okay. And they do it by following all the rules they do in any contract. And I'll give you this example just to show you something you deal with every single day, and yet people don't recognize it. And I'll use the idea of buying an automobile.
Okay.
Let's say that I just have to have, I have to have a 150 Ford truck, and I don't want it to be 4x4. I want it 2x4, but I want to make sure it has the extended. I want to make sure it seats 5, and I want you to know it has all the right color leather and the whole 9 yards. I want the package. And let's assume that the price of that car is $50,000. And I go in and I find the color I want, which is gunmetal gray, and I want to have basically the leather look on the inside because I really want to be a cowboy. And all these other stuff involved. And I have $50,000 in cash. And I go in and say, count out that cash. And they count it out and it's $50,000. And I say, give me the keys. Do you think they're going to give you the keys? Not a chance. Because they want all the limitations in that contract. The reason for it is that's their get out of jail free card, like your contract is a get out of jail free card. And we'll go through those. But use that example. Think of that example. Mm-hmm. Do you think anyone is going to give you anything without you signing some form of contract? Otherwise, exactly, their obligation is unlimited. There's no statute of limitations. And we'll go through that.
Even your phone service has... 100-page contract that's all digital that you have to accept to do. Everything we do nowadays has to have paper.
Well, buy a house, go through an escrow.
Yeah.
I just bought another condo just for as a rental, as an investment. Mm-hmm. There were 317 pages of high boilerplate that I'll tell you, parts of it I didn't understand. And I've been practicing law for 45 years. I didn't understand it. But you have no choice to sign it. And the reason for it in this example is not only are you getting the loan on the property and taking the property as not as is, but in a sense as is, and you have all the terms and conditions, and you've done your due diligence, and that same loan is going to be sold. And all the permutations and combinations of the sale of that loan from, for an example, the lender like Wells Fargo or somebody else to the federales. And the federal government is buying them because they're securing them on the secondhand market. Otherwise, Fannie Mae and Freddie Mac wouldn't exist. And all the terms and conditions, for instance, you can't get a loan on any property that's going to be sold that does not have a termite inspection. Who would know that?
Right.
And all the lending rates and all the exclusions and the points and all this. Look, if you go and buy a house and you buy it all cash, it isn't all cash. It's all cash and 317 pages of documents, of which you have to sign 75 times.
Yep.
So, yes.
That's a good point. And that's the stuff that falls between the cracks that most people don't think of.
Well, most lawyers who do this work, and remember, I used to be a real estate agent and a real estate broker. And I do fix and flips. And I have been practicing basically real estate for 45 years. I don't know all this stuff.
Right. There's a lot. Yeah, there's a lot to absorb there. Definitely a lot to absorb. That was a good point you made there. Good explanation. So inspection contract, once again, it's a contract, not an agreement. I often get that from a lot of times realtors will schedule me. Oh, you're going to send over the agreements? And first thing out of my mouth is, yeah, I'm going to send over the contracts. Okay. Everyone just uses agreement as a slang, that this is what they're using. So, but on the actual paper itself, does it have to say contract?
Absolutely.
So it does have to say contract. And
I'll go one step further since you brought up realtors. What is the document they use for their contract? A residential purchase agreement. It is not an agreement, it's a contract. They call it an RPA, residential purchase agreement, but it isn't. It's a contract.
And it has to say contract within it.
I would look, there's the word contract in it. Trust me. Okay. The car agreements are bulletproof. Yes.
Yeah. Back to the car stuff real quick on a side note. I'm not sure if you're aware of this, but I'm hearing, you ever listen to the Car Pro show?
Yes, I do. The guy is in Texas, Houston, Texas, I believe. No, Dallas. He's in Dallas.
Yeah. And he's got a lot of good info, and I like listening to his shows on the weekends. And he had brought up in one episode where, a lot of people with leases, most people who lease cars, it's been my experience, people I talk to, friends, family, they don't know what they're getting into. I was that same guy years ago, but I learned a lot about leasing and what it means and when it ends and how to get out of it, or whatever, if there's any possibility at all. Most of the time, you cannot get out of a lease. You're going to pay for all those payments that you agreed to from the beginning, no matter when you get rid of it or whatever, you're going to pay for all those payments. But one thing they never tell you when they're about to lease you that car at the dealership is that some of the companies, maybe Ford, Mercedes, Chevy, whatever, Toyota, they require you to give them a heads up in a certain amount of time period before the end of that lease. And if you go over that time limit, they make you turn it in. They take away that option to buy it. But they don't discuss that with you because it's buried inside the contract. That's something I learned about, and I was like, that is interesting.
That is the reason why when you go through a dealership, they are deemed to be your agent. And it's their duty to make sure you know that too. Most people don't think of it that way. They think they're on the other side of the fence.
Yeah.
They have a dual relationship.
They have a duty.
All of us have a duty. The question is to what extent we can enforce it.
Yeah. Yeah. And how many attorneys you have to get you out of it. So yeah, I get that. But that was just a side note I wanted to mention because I thought that was very interesting when I heard about that. And I've been leasing cars for years, and I just found out about that about 6 months ago.
And what you haven't talked about is right now a leased car, if you turn it in early, they will pay you extra to take it back because they have no cars.
Well, that's true. I actually just turned in a lease last year on a 2018 Charger Hellcat.
Okay.
And I only had 4,500 miles on it, and I get paid $11,000 to turn it in. That was nice.
There's a rumor that's true, and you know that's also income.
Yeah, I know. Yeah,
yeah. And of course, everyone has their hand out for income.
Yeah.
Yes.
Especially if your initial start with I. Anything else on that topic you want to jump into? Or?
No, that's fine at this point. You're going to get into all those different terms and conditions.
So, okay. So now here's a really good question for you. I'm a new home inspector. I just started up my business. I followed your rules. I got my federal ID number. I got my business name legally done. Whatever. I did everything. So when it comes to an inspection contract, should I just use what my friend, the other inspector's contract is? Just use that and not worry about it?
I wouldn't. Now, understand that if you belong to CREIA, CREIA has a pretty good contract, in all honesty, and we'll go through it later. But you'll see things, for an example, which were unenforceable, which I changed to make them enforceable. For an example, the 1 year statute of limitations versus 4. Mm-hmm. Most people think that in a written contract, it's 4 years. And in California, it is.
Yeah, it is. Yeah.
Well, it may be.
You changed the rules?
Sure. and this is how we did it, is that no, let me stop for a second. That isn't really true about it is. There is case law, for instance, that says in insurance death policies, so you have a life insurance policy and somebody dies. Depending upon the terms and conditions of that very long agreement, like we talked about the escrow, there may be a clause in there that says we must know within 6 months, not a year or not 4 years. And there's case law at the Court of Appeals that says if there is a specific time limitation based upon consideration that is found to be valid, there can be a reduction in the time. Now, let's take CREIA, for instance, because it's really much better policy.
Yep.
California has Business and Professions Code 7195 through 7199. Everyone thinks that 7199 says there's a 4 year statute of limitations because no action can be brought against a home inspector after 4 years from the date of the inspection. That is not true. That is not a 4 year statute of limitations. That is a limitation on the filing. But you can be brought in on a cross complaint 3 years, 9 months, 10 months, 11 months later.
What is a cross complaint?
A cross complaint in an action is there's a plaintiff's complaint. They sue certain defendants. Defendants can file cross complaints against various parties. I make it a policy that if, that's why it says in my contract, that there is a duty of the plaintiff to read all the terms and conditions of the contract, of all the reports, and if they don't do so, an allegation can be made of a cross complaint against the plaintiff because the plaintiff did not fulfill their duty. I get a lot of kickback. There are a lot of people that really don't like me because of that. And you want to know something? I lose sleep every night over that. I really, really do. And I don't at all. The bottom line of it is if they're an idiot and they don't read the stuff in front of you and it goes badly, well, this is something being recorded, so I can't say what I really want to say, but I can say that the word is a 13-letter anatomical improbability. That's what I can tell you. Bottom line of it is is that a plaintiff owes a duty, a buyer owes a duty, a seller owes a duty. All of us owe duties. If you choose not to do your duty, you know what happens. You're named as a party. So that answers that question. So think of it this way. You can be brought into any case at any time. It says, if in fact more than 4 years have passed since the date of the inspection, the plaintiff can't name you. I just got a case in the door in which it was 7 years after the inspection. A commercial inspector was brought into a lawsuit, and we are just getting the information necessary to file the motion for summary judgment. And then after we win, which we will, I've already told the client they're going to win, is that we're going to sue them for all the damages. Now, as you know, and I've told you this beforehand, we have collected, I say collected, I don't mean got judgments, I mean money in hand and divided, in excess of $1.3 million for home inspectors, and I'm getting more all the time.
Let me ask you this real quick before you continue. What is a summary judgment?
Summary judgment is a motion before the court that says, I don't care what you believe or you don't believe. In this case, it was the statute of limitations. But the statute of limitations says, worst case scenario, 4 years. Worst case scenario, everything all from a plaintiff, 4 years. Now, if it were a construction defect case, as you well know, there's a extension that can be done when it's called the delayed discovery rule. That does not apply to home inspectors. And there's a landmark decision called Moreno versus Sanchez, which is a Orange County case, came from a Los Angeles decision. So I'm sorry, that's true. That's not true. It was a Los Angeles case in which it was transferred to Orange County because the commissioner who brought the action was in Los Angeles County. So it was transferred. But the decision by the judge, it's called a centennial case, says that no, they must bring an action within 4 years, which is what Business and Professions Code 7199 says.
Got it.
So that summary judgment means there's no triable issue of fact. Therefore, as a matter of law, the court must grant it. The best ones are in statute of limitations because that's a definitive time.
Right. So summary judgment, you're basically saying you have nothing.
You have no case against this person under these facts.
And now you're asking for a sum of money in return for or not.
Well, what occurs is when the summary judgment's granted and it runs through the appellate period, you then file your cost bill. Now, if you have the right contract, in other words, if you have my contract, what occurs is there's an attorney fees clause.
Yep,
and that's
we're going to talk about that.
Oh, yeah, I bet you're going to get into that. Yeah. And it's amazing how much they like the money coming back. One of the former presidents of the LA Ventura chapter, I got a judgment for in 2002 for $52,000, I think it was. But because of the rule of law on collections, the house that you try to sell for the purposes of doing it, the law changed, saying there was X amount of money that was theirs, no matter what. We had to wait until 2020 to bring that lawsuit. We waited 18 years, got the judgment extended twice, and then foreclosed on the house. These people claimed they had no money. The judge held it in bay. Went up to the bankruptcy court. I went up to the Court of Appeals, and it came back down. I'm sorry, it went to bankruptcy court. We got it out of bankruptcy court, and it's amazing how this individual, who's a structural engineer, living in the house with 6 kids for all those 18 years, that was inherently dangerous. It's amazing he didn't have any money, but the next day he had $190,000 to give me. I mean, it was a miracle. I mean, everybody knows it was just a miracle.
Dude, that's hilarious, man.
So the former president of the LA Ventura chapter got his money plus interest. It went from $52,000 to $220,000 on 10% interest per year. And when you then redo the judgment, the interest on the judgment becomes the new judgment, and you get 10% interest on the interest.
Wow, that's nice. That's a good investment, actually.
Actually, it was. My wife thought it was very beneficial when I brought the money home. She liked it. Okay.
So let's just let's see. I had a couple of things here. Okay, so another question regarding the inspection contract. Will any attorney suffice for a home inspection contract? Like if so-and-so, let's say I'm just this new guy, doesn't know who to turn to, who to talk to, can't get good advice from anybody around him. He just calls so-and-so family law and says, hey, can you do a home inspection contract? And they say, sure, we can do that for you. Is that something you'd recommend? I mean, what do you think?
Let's try it differently. If you developed a new software, and this is going to go and you're going to get patents, copyrights, or whatever you get, and various other things. Would you go to a family lawyer?
No.
If you had a medical malpractice case where a doctor unfortunately ended the life of your child, would you go to a family lawyer? The answer is pick the specialty. There's a reason why a person's in a specialty. It's because they have more background, education, experience. They know the cases that match up, and you go to a specialist. More mistakes are made by lawyers who have committed malpractice and have been found to commit malpractice by stepping out of your comfort zone.
Right. Stay in your lane.
Right. The same thing applies to a home inspector. If you do family homes or condos or so forth, you don't do 60-foot skyscrapers.
Right.
The answer is do what you do best, right, and do it better than anybody else.
And find the right people to set you up. So just what I hear a lot and I see a lot over the years is a lot of home inspectors. Oh, hey, do you have a contract I can use? Yeah, sure, I'll send it over. And I'm like, you're not going to have your own lawyer look at that? Because taking a step back for a second, we talked about CREIA contract. Now, just to be clear, if I use a CREIA contract and there's all of a sudden there's a claim against me, some kind of a demand, will CREIA be coming to court with me?
Of course not.
My point, exactly. So once again, I'm sure, like you said, CREIA has a very good contract, but you still need to have this looked at by your own attorney
who specializes in that area of the law.
Right. So that's something that is unsaid and has been unsaid for a long time. No matter what meeting I went to or what conference I went to, no one's ever said, oh, by the way, you're on your own with this. You're going to have to get your own lawyer if you're not insured. But that's a different subject we'll get into shortly. But let's jump now into...
since you're right there,
okay,
let's think about this. For a long time, CREIA was told, do not have an attorney fees clause. Well, ever since I became very, very successful at bringing the money back in, it's amazing how the thought process is, I want a piece of the pie. The next thing that you'll see, and we'll go through it, is they talked about various aspects that you inspect for, but nobody mentioned systems. And if you relate everything to a system and you have the right paragraph before and you call out a system, it is a get out of jail free card for any other part of that system that you may have missed because you called out a person in the system.
Right.
That also changed. That's just another one of the ideas that, and by the way, it wasn't just me, that there's a number of people that thought this out, and we would meet every so often and go through this. Alex Chichinsky was one, Farmer. There were quite a few people that jumped into the bandwagon to upgrade it. Ashley didn't do that. Ashley was late coming into it, and Ernachi was late coming into it. As a matter of fact, it used to be that CREIA borrowed Ashley's. And because they were once together, Ashley's now coming to CREIA and say, can we see your contract? So go ahead.
We're evolving, right? Everything's evolving. Okay, so then I wanted to. Well, let's go right into the attorney's fees clause. So I just recently, my previous podcast, I had my insurance company representative as a guest, and we talked about stuff, and we talked about a lot of stuff. Mostly, it's all about risk management once again, and that seems to be the biggest open door for a lot of home inspectors. They're not quite aware of a lot of these details. So when she got to the topic of attorney's fees clause, she called me out on that, and I said, well, I don't mind you calling me out on it. It's in my contract because I had a very experienced lawyer do it. So what don't you like about it? The insurance company I use, Inspector Pro, is not a fan of it. Well, so hang on.
Good, sure.
So she kind of, was just like, well, we had it work in reverse before. So basically somebody had that clause, a home inspection company that they represented, had that clause in their contract. Turns out they were found
negligent,
not negligent.
Okay.
And basically they were told, okay, you're not at fault here. However, because it said that clause was in the contract, the plaintiff, they were ordered to pay so much money for all the attorney's fees that because of the rest of the people involved in the case. So I'm like, how did that happen?
Okay. This is a bigger problem, and
Right.
maybe now's the time to talk about it. California is different than New Jersey,
Right.
which is different.
And that's what I brought up. Yeah.
Now, Louisiana, the law is based upon French, or really it's called Napoleonic law. And Texas is different, and all of them are different. That is the problem that we have at CREIA. We have a different world. We don't want to be dictated to by another entity that has different rules, different regulations, and the way to get around it, we have figured it out in California.
Right.
Keep the attorney fees clause. What you do is you then go to what we call a CCP 998, Code of Civil Procedure 998. And that is called a statutory offer of compromise. So where we have, let us assume that we have a home inspector who just, whatever reason, had a bad day, and it's a 3-bedroom house, and they only inspected 2, and the third one was a disaster. What they do is they analyze the actual cost to rebuild that. And then you say to that person, we are willing to rebuild it, and let's assume that it costs $30,000 to redo that bathroom. They make a statutory offer of compromise at $30,000 plus 10%, just in case the bid's a little over. And they do a statutory offer for, hypothetically, $33,000. If the jury comes in, and it has to do with everyone, and let's say your proportionate share in California is $20,000. You're responsible for 20, but the other parties should have noticed the same thing, and they were found to be less responsible, and they're held for $10,000. The fact that you offered $20,000 and they didn't take it means that you are the prevailing party and you get your attorney fees. And there was a landmark decision having to do with construction defect, where there was a problem with plumbing. It wasn't soldered correctly. And in fact, it went through a 50, 60, 70, maybe it was 100 homes in a large development. A construction defect case came about. The plumbing company, day one, came into the case and said, you're right. This is what it would cost to fix it. This is your downside, and made them a statutory offer for, it was in the millions. They wanted a lot more. They won the case.
Who's they?
That is the plaintiffs in the action.
Okay.
Won more than the amount, and let's say the amount was $2 million. They won the case for $20 million, but as it relates to the plumbing problem, it was less than $2 million. That the attorney fees were greater than the $2 million at the end of the case. The plaintiffs in the case ended up paying on the statutory offer. They had to pay the attorney fees and costs.
Oh, wow.
Yes. So what it means is you have to be reasonable. So let's just take our case that we just had. Well, all they had to do at InspectPro is to do a statutory offer of compromise for an amount worth more than the claim is being made. And had that occurred, yes, there may have been a $20,000 instead of $30,000, but the attorney fees done by the lawyer on that case itself, and all the other attorney fees from all the discovery done by everybody else is all added in. So I'll give you an example. We had the Miss Google case, the one I told you about beforehand that had like 8 or 10 lawyers. And the bottom line of it is that it.
Did you say Miss Google?
Yeah, Miss Google. She was a high executive for Google, a big time player.
Okay.
And she came from a very wealthy family, and her husband was one of the 5 big milk producers in California. Look, they had more money. When old money was old, they had old money. Okay. And it was a terrible situation, terrible thing with the house. It was a disaster. I could spend 2 hours just talking about that and I wouldn't even cover it. We figured that at the end of the case, we had to process in excess of 1 million pages of documents.
Wow.
Yes. Okay. All I can tell you is this, is that that was just an example of the way these things take place. And that's why you do things the way they're set out by code. So the answer is all they have to do, and if that issue comes up, all they have to do is a statutory offer of compromise. And it's done every single day.
Right.
In PI, it's done all the time. It's a standard thing.
But I think what you're getting at is each state, it may work differently.
No, I'm saying the law is different. I'm saying in California, all they have to do is a statutory offer of compromise, and they resolve the whole thing about the attorney fees.
Got it.
It's a non-issue.
Okay. So I'm pretty sure the people she was mentioning were from a different state. So like I said, different laws over there.
No, it's in California. I hear adjusters say the same thing over and over and over, and I stop and I write a report on it saying, no, this is what you do to correct it. The problem is the adjusting services, because a home inspection industry is so small, there's so little training. They don't know what you do. Right. That's the problem we have. That's the biggest problem in CREIA right now.
Got it.
And we'll go into that later. Go ahead.
Right. Okay. All right.
Attorney fees is a non-issue.
Non-issue. I like to hear that. All right. That's good. Okay. So report writing. And I bring this up because when I'm inspecting a system, the inspection starts here and ends here. So if I'm inspecting, let's use HVAC, heating and cooling, for example. So my example is John Doe's heating system is working. However, the AC side of the system is not working. It's not responding. There's no way to turn it on by using normal operating controls, such as a thermostat. And in other words, it can't be tested. So I can't tell you what's going on with it. So the inspector reports that the AC unit is not working and recommends further evaluation by a qualified licensed HVAC contractor immediately. Is that alone considered enough to cover the issue with that system?
No.
Or should the inspector also have included the AC unit has other visible defects, such as a missing safety pan, a missing safety switch, or an electrical AC disconnect that's the wrong size per manufacturer? So are you following that question?
I've got it.
Okay, go for it.
First and foremost, we do not go to manufacturing specifications because we are not experts in that field. So that is an out to start with. But what we say is that before the close of escrow, A specialist in HVAC needs to go through the entire system, in that we are not specialists in the manufacture or in the installation of this particular unit. Something like that. So what you need to say is you leave room for something else, but it's the system. They must review the entire system, and it must be during the escrow period.
Okay, so then I would change my wording to recommend further evaluation of the entire heating and cooling system
During the
or,
escrow.
Well, what I typically put is before the end of your inspection contingency period and the close of escrow.
Yes. In fact, it is even better if you leave out before the close of escrow, because it's during the contingency period. Remember, they can extend the contingency period.
Oh, so just the close of escrow will suffice?
No, it will be during the contingency period.
Okay.
The contingency period may come to the day of escrow.
Got it. Okay.
It may be before.
Okay.
You don't want to get in that area at all.
Okay. So that would be enough to cover the example I gave you if I worded that correctly.
Yes. Now, there's one other thing that you want for each system, though. When you go to a system, you have a heading at the top, and it basically gives a brief layman's-like instruction, yes, on exactly what is in each system and why it's so important to have an expert. If there is a warning, a call out of any condition found within that system, it is the responsibility that an expert come out and run the complete system and give you an evaluation, again, of the complete system, not just what you found.
Right.
We have a case that just finished about a year ago, and it had to do with that exact issue where there was a flooding of the house, and of course the realtor didn't tell anybody about it. It was a fix and flip. But to make the long story short, is that the home inspector found areas in which there was a question of water intrusion and called out for that very issue to look through all of the HVAC system, because they basically had vents in the house on the floor. So with all of that in mind, it said the complete system. Now, we walked away from that case, and they got a little over $1 million and change, and we were dismissed for a waiver of cost at the time of trial. The reason why was we had an attorney fees clause, and they would have never got us. Okay.
So, I mean, thanks for shedding light on my question there. That was kind of where I was thinking it would be, but I wanted to bring that up for all the listeners to get a grip on that, because, once again, where does the CREIA standards of practice, which is what I follow, does not say specifically where my HVAC inspection starts. It doesn't say what thing to look at. It doesn't say what exact component. It'll say heating system, cooling system.
Generically.
Yeah, generically. So as a home inspector, this is something that comes in, that rings in my brain quite often. It's like, okay, well, I start here and I end here. If I'm going through steps 1 through 10 and I get to step 5 and this thing's a mess,
you stop at 5.
That's the question.
The point of it is, you are not the expert. You are the person who generically finds a condition. Think of yourself as a GP, general practitioner. And a person comes in and you do a physical exam and you hear what you believe to be a heart murmur. You don't treat him for his heart murmur. You send him to a cardiologist.
Right.
The same thing applies here.
Sure.
You are a generalist. You always send them for a complete, in essence, physical exam of that system.
Right.
You differ.
So here is another scenario for the same type of system. So I'm inspecting a system and it looks like Daffy Duck installed it. I mean, it's just a mess, which takes me a minute or two to realize just by looking at one section of it here, one section of it. It's ridiculous. I see this a lot. Joe homeowner put it in, or the cheapest guy down the street put it in.
Oh,
so what I do,
good.
So what I do when I see that, even if it's running, even if it's working, even if the temperature splits are decent, I call out to my client and I let them know non-standard installation of the entire HVAC system has been observed. I'm recommending you get the entire system further evaluated before the end of your escrow and contingency period. Would that blanket cover the whole system if I see that?
Yes, I would use the term, there are abnormalities present in the system.
Abnormalities.
Yeah. Abnormalities is a very interesting, large word that covers a lot of different areas. There are conditions present which do not appear standard. There are abnormalities. And as a generalist, I'm calling this out for a complete inspection of the HVAC system as a for safety reasons.
Okay. All right. Yeah. That's a good answer, because that's not the answer I had.
No, remember, we all grow and we all learn and we all modify. Everybody amends their own stuff. Yeah.
That's why I brought it up, because it's, I can say the same thing for a water heater.
Electrical system.
Yeah. Electrical system. Same thing. I have those types of comments ready to go in my reports if I see an electrical upgrade and it looks like, Daffy Duck installed it or whatever, the whole Looney Tunes gang was there.
Or different wiring.
Yeah.
Or any of those things. The point of it is you are the GP.
Yep.
You defer to the specialist. And by doing it that way, that is the real protection for your client. You are not hurting your client. You're helping your client.
Right.
I'll give you an example of when I just got in.
Attention home inspectors. We all know the challenges of trying to market our businesses and run them at the same time. It's hard to do marketing while you're under a house in a crawl space or up in an attic. So don't give up. There is a solution, and it's called HomeInspectionAndRepair.com. Home Inspection and Repair offers a practical and inexpensive way for you to be found by motivated clients seeking the services you provide. Once you join, your profile will tell them why you are the perfect home inspector for them. We're building a way for homeowners and real estate agents to find you easily. So position yourself prominently at HomeInspectionAndRepair.com.
It's a house on the side of the hill. It had massive foundation problems where the foundation was falling in itself and turning. There was a wall, a retaining wall. Mm-hmm. There were problems all over. The home inspector did a magnificent report with photographs documenting this beyond existence. I represent the structural engineering company that came in that only could get a limited view of it. That occurred in 2016. 1 year statute of limitations, again, I wrote their contract. The next event that takes place in 2 years later, in 18, it's getting worse, and there's actually a separation inside the house, and they were never allowed to come in the house. Now we're at 2022, and they're bringing a lawsuit right now. The answer is we have so much information because there were deferments, etc. The answer is this is really what occurred, and this happens all the time. Somebody doesn't really want to pay the full cash price, so they find these things, and they go back and renegotiate it. Now, of course, the fact that the buyer, his wife had just passed the bar and was a very bright lady, and the husband was in high tech and knew that these problems, and they saw the fact that this was a problem. And one of the foundation walls that was holding back, where the garage was located up above, they could see it deteriorating. So they went back, and we don't know how much money they got back, but they got I was about to say something else, a large amount. And they pocketed the money. They didn't fix anything. And now they're
shocking,
yes.
Shocking chain of events, yeah.
Anyway, the bottom line of it is that's where we are now, and we are in litigation. Well, we will be in litigation soon. We have to go to a mediation. But I have told the structural company, stop worrying about it. You have an attorney fees clause. Yes, I will be getting a lot of money, and I thank you for it, but I'll get it back.
Right. You just mentioned litigation. Can you explain what litigation means in that format?
We see it on TV all the time about somebody suing somebody else. I have to tell you, some of the TV stuff is really pretty
So it's
good.
just the process is called litigation.
Yes, it's a process, and it starts with notification, mediation, a complaint, then the cross complaints, and then you get through all this litigation stuff, and you go through another mediation, and then the judge says, no, you guys are going to go to trial. You go to trial, it ends, then you have the appeals. It is a lot of forever, as we call it.
Right.
Again, it's a process. It's the same thing, unfortunately, and I'll use the analogy of cancer. You're diagnosed with cancer. Mm-hmm. You go through a process of remission for the purposes of finishing and going forward. It is a process. It's not a pleasant one.
It's a process like everything else. It's a process.
Like paying your taxes is a process.
Going through a mold remediation problem is a process.
Yeah.
Just had that on my mold podcast. So jumping over, did you have anything else you want to add real quick? Or?
No, that pretty well covers.
Okay. In my dealings with home buyers on a daily basis, by the way, I'm exhausted. I had a long week. I did a house every day, a lot of brand new home buyers, realtors who just were annoying me just by asking me the most repetitive, ridiculous questions.
They want the money. They want the escrow to close.
That they should already know. And today's Saturday, and I'm just like, I don't want to look at a drain pipe. I don't want to look at a heating and cooling system. I just wanted to sit here and talk today. So that's why we're here today. But anyway, what I get as a constant problem, which annoys the hell out of me, I've sent, typically when someone hires me, they're getting my inspection agreements pretty quick. Typically,
contract.
Contract.
Go ahead.
I just slipped. They're getting my contract and payment link typically 2 to 3 days in advance. Most of the time, they digitally sign it. Everything's good. They make the payment. Everything's scheduled. So when I show up, I can just focus on my job. Okay. And then at the end of the inspection, after they supposedly read everything I sent and everything else and all the information I provide to make this a smooth process. And this goes for their realtors too. First thing they ask is, oh, did you check the lawn irrigation system? Well, no, I don't. It's on page 1 of your inspection contract.
And it's on page 2 of the 4-page CREIA Standards of Practice, second column on the left.
And then number 2, by the way, your house has solar. Oh, did they work? I don't expect solar. And that's also on page 1 of your inspection contract. Well, what about the fire sprinkler system? I don't check that either. Okay. Now keep in mind, I've already gone through my findings and I told them they have 3 foundation cracks that definitely need repair. You get major drainage problems around the house. You got mold inside the house, what looks like mold inside the house. You've got all kinds of problems here. And these are the questions I get asked first. Not, well, how much is that going to cost? Or how much is it? It's just so outlandish, the questions I get. So the reason why I'm bringing this up is I've actually added, if you look at the front page of my contract there, it should be right under that. If you look right here.
Yes.
I added something to my contract because it's a daily occurrence and I'm just tired of dealing with it. And it seems to help a little bit. I know it's in the CREIA Standards of Practice, what I don't do, but these are the main things that come up all the time. So I added this in the first page. Be advised, the following systems are outside the scope of this general home inspection and are specifically excluded. If any of these systems are present in subject property, I recommend you contact a qualified professional to inspect and test these systems before your inspection contingency period ends and the close of escrow. Is that okay?
No.
No. Okay.
Here's the problem.
All right.
When you make special notation as to some exclusions, and there are other exclusions in the standards of practice, have you waived the others? So the answer is, look, one of the inspectors that I do business with, the day before the inspection, he resends the standards of practice again and says, understand, these are outside the standards of practice. I'll see you there tomorrow.
Got it. Okay.
Now, the reason for doing that is you told them up front when you sent your contract and the standards of practice.
Yep.
You now reiterate before you go the day before, after you get their money and after you have the signed contract. The second time. Why is this so important? It says, I'm always asked these questions. Let me tell you up front so you're not worried about it and you can take steps necessary to approach this issue should it be addressed.
Right.
These are outside the standards of practice. We are generalists. These relate to specialists.
So in other words, take it out of here and just put it in an email body.
Right.
As a reminder.
What this may do, let's assume that you had a really good attorney like me, and of course I'm modest. And let's just assume further.
Are you really?
Listen, I'm just a low-key guy. Bottom line, let's assume that I were to argue this position. I would say, but you included these, but you didn't include those. Why wouldn't my client understand that you're going to do the other because you didn't include them?
Right. Well, the bottom of my contract is the standards of practice.
Of course, but
So it all comes together.
But you specifically identified these.
Right.
But
Those are the most frequently asked.
Okay. The point is, sometimes being the greatest guy there is in helping people is putting the noose around your own neck.
Got it.
You got to remember, you have a job. You only do your job. I told you before we started this about the roofer. The one I was asked to do this plaintiff case because it was very problematic. It was a personal friend, and I wanted to help his friend. And this house was a disaster. And a roofer came, and I got to tell you, I told the guy, walk away from it or get a rescission. Just get a rescission. You don't want any part of this. You don't want any part of this house at all. The whole thing was, if you pushed it too hard on one corner, the whole thing fall down. And of course, they added a bedroom with no permits and stuff like that.
Right.
So anyway, you've got the story. And this roofer, who was obviously, they didn't interview him first because the guy wouldn't get on I wouldn't let him on front lawn. I'm on my front lawn because you just see a person and you look at them. And it was automatically a no before we started. Okay. I mean, he wasn't out of the truck 2 feet before I said no. Okay.
Right.
That's what I would have done. So anyway, turns out that he got up on the roof, saw there was problems as part of the home inspection. He said, excuse me, I have to get down. He got down off the roof. This is the story. He got down from the roof, went to his truck, filled out a form and said, here, I'm making an offer to fix your roof. Right there. On the spot, hadn't even given his home inspection report yet. And he was hired to do a home inspection only.
Wow.
Yeah.
Yeah, that's a little fishy, people.
Well, it's a violation of law.
Absolutely. We're not supposed to. Well, if we do offer any kind of a repair service, it has to be after 12 months, correct?
That's correct.
Yeah.
But he hadn't even got the job yet. I mean, he hadn't even done
the report in. Yeah.
And he missed one whole wall that was completely decayed by termites because he didn't want to remove a screen. And the screen was right there and falling off. All he had to do was get a flashlight.
Yeah. Yeah, that's a little crazy.
Yeah, I passed on the case.
Did you?
Yeah, as soon as I got this stuff and found out what's going on and whether the guy had insurance or not, it's another story. But the whole thing was that way.
Right.
Anyway, go ahead.
What's your thoughts on a home inspector having insurance? Is it good or bad?
You have to have it. It is a mandatory. It is not a question. if you have insurance on your car, you should have your insurance. Remember, bankruptcies are not
You
fun.
sound just like I did the other day.
You have
Saying
to
the
have
same
it.
thing.
But having insurance is the start.
Right.
You have to have an insurance company that specializes in this, who understands the standards of practice.
Yep.
And again, when we get into the agreement itself, we're going to get into this mediations and stuff. And I want to tell one story up front, and then I'll let it go.
All right. Shoot.
As you are a generalist and defer to a specialist, when you get a lawyer, you think that you're getting a lawyer who has background, education, and experience in your profession. Remember, you are as much a professional in the state of California by law as a doctor, I would say a lawyer, but lawyers aren't professional. A lawyer, a dentist, a chiropractor, or any of these professions. I once had a mediator. This is a person now that is so experienced, he's brought in to sit as a quasi-judge to help you through your program because he's much smarter. And he kept putting in a standard for a licensed contractor. And this is what it is. This is statute of limitations. This is construction defect, blah, 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 blah. We're down the line. And I turned to him and said, well, what about CREIA? He said, you mean the country that's north?
You mean Korea?
North and west of Japan? That's why in my contracts, it says a person with background, education, experience in the standards of practice for CREIA. If they don't have that, you're swimming upstream.
Right.
They have no idea what they're doing. Anyway, go ahead.
Yeah.
Continue, please.
No idea. I mean, it's funny you mentioned the Korea thing because when I do my transcript for my podcast, it always, when I say Korea, it always puts Korea. So the softwares think in the same way this judge was. By the way, a mediator, is that what you said?
Yes, a mediator.
A mediator is basically a judge who comes in without a courtroom and sits between the two of you, right?
No, it could be, I sit as a mediator all the time, and I have 45 years.
You can just be an attorney.
Right. The key to it is someone who can understand the issues present and try to lead people, not taking a side, but to a point where both sides are very unhappy, but they settle it and close the case.
Right. Got it. Okay. All right. So let's get into this contract. Where would you like to start?
Well, first and foremost, you need a completed contract, and you need to have one that covers all the issues that you have. For an example, the first thing is any person who's going to deal with this contract must have background, education, experience. So let's just start with the people that judge it. A mediator must have background, education, experience in the home inspection industry. So therefore, let's do it differently. You must control the narrative. So here we go. The first thing is I have it written in my mediation clause, requirements that are deemed draconian or basically harmful. Not harmful, but strict. In other words, anybody can say, well, I know the construction industry, so therefore I know CREIA. I know that CREIA standards of practice. The answer is they don't. That's the whole point.
Exactly.
So I don't demand who they be. I only demand that the individuals chosen from must have the background education experience. So when, for an example, they send out a list of 5 or 6 names of individuals, I contact them and say, basically go into the CREIA standards of practice and do they know it? Well, I don't even go that far. I go and look at their resumes, whether it's JAMS, ADR, whatever it is. And if they don't list that they have background experience in the home inspection industry and the standards of practice of CREIA, they can't even be on my list.
Right.
So I eliminate all those ahead of time. And I'll give you an example. I once tried in the front page of the Los Angeles Times, there was an article about the vexatious litigant lawyer who had sued all these different people to get money and had made a fortune on it. And this time he was paying $168,000 to a law firm because they got him for attorney fees. It was my law firm. We got the vexatious litigant lawyer, and the other individual involved in that case was a guy named Rick Gore, who represents realtors. Bottom line of it is they talked about all these atrocities that this guy had been doing, intimidation, the whole works. In this particular article, it talked about him being a vexatious litigant lawyer. They're all out there. A lot of them.
Explain vexatious.
That means you purposely file lawsuits that you have reason to believe are invalid and shouldn't be filed, but you do it in order to get nuisance value because the insurance companies roll over. They don't want to pay the litigation costs of going through it, which is the biggest problem in our industry right now. The insurance companies are giving away money.
Yep.
So let's now come back to where we are. I have it limited in mind that says that they must have background education experience or they can't even get on the list. So when the list is sent out and I go through them, I write back to ADR or JAMS or something like that. And I'll say, in order to get on the list, according to this contract, they must have background education experience. I've read their resume. They don't mention CREIA or the home inspection industry at all. You need to give us 5 more that have that. And if you don't have them, we'll go to the next one.
Right.
Now, there's a rumor. There's just a rumor now.
Just a rumor.
Just a rumor that certain people do provide the standards of practice to certain mediators in advance. And there's a rumor that they put in saying they have read the standards of practice on their resume. And golly, I think that qualifies them to be on the list. And I'll give you another example where I tried an arbitration case. And this happened to be a case for La Rocca in which we won, but it was a major case. And we had an arbitrator. The arbitrator found for me, which I knew he'd do. And we then went back for attorney fees of $300,000, and we eventually got some money. The key to all of this was he then became a mediator, and he was assigned to one of my cases. So we're now sitting around the table, and we have plaintiff's lawyer and the client, and I'm sitting across the table with my client, the home inspector, and the mediator turns to the plaintiff's lawyer and says, well, explain your case. And he goes through his case and his client says a few words and so forth. And then he looks at me and he goes, wait a minute, Mr. Pyfrom. And he asked the first 10 questions that I would have asked. I'd had so many mediations with him. He already knew the first 10 questions. And by the time he finished the 10 questions, he said, look, you don't have a case. I never got to say a word at the mediation, not one. And eventually what occurred was they gave us a dismissal for a waiver of costs.
So he told the plaintiffs they had no case.
Right. Basically, I mean, yeah.
Because he understood
He
standards.
knew the whole standards.
Yep.
He asked the questions when I was there.
Got it.
Okay. And then he stopped me from saying a word and said, Mr. Pyfrom, you client step out. And then he told him, he says, you don't have a case. You're going to lose. And he's going to come after you for attorney fees. And he got $300,000 from this one on another case I was on. He said, you don't want to do this. Just die.
Just run.
Yeah, right. So then he got up, he left them there. He walked in and said, Greg, I've got you a dismissal for waiver of costs. You're going to take it. And I said, I want the attorney fees. He said, no, Greg, you're going to take it. I said, oh, I'd take it. Sure. The client just wanted out.
Yeah.
Okay. But you have to set the stage for the right players.
The narrative.
So you've got it going, you've got the narrative, you've got it set up. Now, I have gotten more cases dismissed on an oddity. And I don't know why, one day I came up with it. And that is, a lawyer has to give notice to the other side as it relates to a demand for mediation. That is case law. Okay? Or you lose your attorney fees. Now, in every real estate transaction, it has that. It's generally paragraph 22 or 23 found on page 8 of the standard residential purchase agreement, RPA. And generally speaking, on the next page, page 9, depending upon which form you get, is either paragraph 25 or 28. That's the attorney fees clause. Just happen to know that. So, all right, now we come to the next side of it. The next side of it is how do you get to a point that you can get the cases dismissed day one? Well, this is what you do.
Wouldn't that be lovely?
I get it done all the time, and this is how it is. In my contract, it says that you must give notification of a demand for mediation, not just a demand, but it must be sent return receipt request before you file your complaint. Why? Because if it's not return receipt request, it's amazing how they have a copy of that notification. You just got lost in the mail if you don't have return receipt request.
Yeah.
So therefore, they call me up when I say, "Are you giving me a dismissal?" He said, "Why?" I said, "Because you didn't do a mediation." He said, "I'm sure I've got it." And he said, "Remember, return receipt request. Do you have the document?" He said, "Let me take a look." And he calls back and said, "Would you accept a dismissal for waiver of costs?" Day one, right out of the bag. And the answer is yes, because the insurance company's going to say yes, and they've got no damages. But that's why it's in there. But CREIA took it out of theirs.
Right. Well, this, let me, am I interrupting you? You
No.
got something else to say? Okay.
No.
All right. So basically, this brings up, remember about 4 or 5 years ago, I was talking to you and I said, hey, you know what? I got this bogus claim about a mold issue on a house that I reported, like 14 different areas of the house. I had moisture damage, recommended further evaluation of all the problem areas. So long story short, several months later, I get this demand for $5,000 and they try to take me to small claims court. And I'm like looking at my contract, I'm pretty sure there's a mandatory arbitration.
In my contracts,
Arbitration.
there is. In my
right, it's right here.
No. In my contracts, it says you have, by signing this contract,
Correct.
You agree that you cannot go to small claims except for the price of the inspection agreement that's done by the contractor. Inspector, I'm sorry.
So basically, I had to get my insurance company involved. And then they found me a lawyer here in LA who, to me, was useless. And I remember telling you about this. You might have forgot about it. So all of a sudden, I'm like waiting for things to start happening. Like, I got everything together. I got my report, my contract. There's no issue whatsoever with a signed contract being, invalid or anything like that. That was all a no-brainer. And then I contact the lawyer's office and I get this assistant or a legal aid. And she's like, okay, we're going to help you get ready for small claims. I'm like, what? You're going to do what? Well, this small claims complaint, we're going to get you ready for it. I'm like, did you guys not even read the inspection contract I sent over? It's got it right there. It's a mandatory arbitration here. So why are you prepping me for small claims court? Shouldn't you be sending a letter back to the plaintiff saying, hey, look, you just breached your contract by trying to take us to small claims court? Because it clearly says that's not what we agreed to. Amazingly enough, the next day, they send that letter after I asked them to send it. Went away. Just like that.
These people, look, insurance companies.
What I'm getting at is the lawyer never read the contract that was supposed to be representing me.
No. What happened here was the insurance adjuster that you paid money for didn't read it. Okay. The key to this is, think of it a different way. You are an orthopedic surgeon. In doing a knee transplant.
Do I get the money that goes with it?
You don't get the pain either. You're an orthopedic surgeon. You're replacing a knee, and it goes badly. Would you want a family law lawyer representing you?
Absolutely not.
But that's what they're doing now. They have no respect, the insurance companies, for your standards of practice. I've been fighting this now for just under 30 years. That is the problem we have, not you,
right,
but all of the home inspectors, because they don't do what other professions do. And I'll give you an example. Dentists were in the same situation. They were getting hammered. So they hired an insurance agency that combined everybody together in one basket. And then they said, I have 300 of these policies, or 500, or whatever the number was. And they went out to all the professional insurance companies and said, if you want all these policies and the premiums, you have to bid for it. And you must have these specialists handling it who specialize in this profession. their rates dropped 22% in 3 years.
Wow.
There was a company that I was dealing with that when I was brought in, and I won't mention their name, who was paying over $100,000 a year for insurance with 12 inspectors. Now they have far more, and they're paying just under $30,000 a year for the coverage because they went to a $25,000 self-insured deductible where their people came in, they handled it, and they took care of it. And the insurance company was notified as to settlements, but they could not control what was done in the case.
Got it.
We have another case that I filed a summary judgment on where they blew the statute of limitations by years. The insurance company is upset because of the amount of time and money I put into that case to get the information, to get the client off for nothing. And they're saying, I'm spending too much money. And they're going to get the money back. Look, they don't care. You are such a small grain of sand.
Minuscule, yeah.
The key, though, is if you control the narrative from day one, they make nothing but money. Nothing but money.
Got it.
Go ahead.
All right. So, well, let's see. What do you want to point out on?
Let's go through the contract.
Yeah.
Okay, here. I've got it right here.
Oh, you do? Okay.
First and foremost, the scope. You're a generalist. You say it. It's a system. Everything is system generated. It is not item. It is not an electrical, whether it is a switch here or a switch there or any of that. The key to this is it is a system, and you have your great paragraph at the start stating about the system and how it works and how you inspect. And you say anything found, any negativity found in this system calls for a specialist in this condition. Not everything. And you say right in the front paragraph, because of the level of specialization of this system and the person that installs it,
right,
they have far more background education experience than any home inspector. Therefore, if one thing is called out, they must do the complete inspection of the complete system throughout the house. That takes care of the systems.
Now, when you're talking about a system, I understand you mean heating and cooling, electrical, plumbing, foundation, all that. But what about like a bathroom? There's so much going on in a bathroom. What about a kitchen? Would those be considered systems or not?
No. It is an electrical system, a heating system,
right,
a roofing system, a foundation system. Now, there are things within each room, though. For an example, there may be the framing, the structure. We had that big case in Sacramento, which is going to be as part of my talk when I go to the lecture, with a 100-foot sycamore tree. And of course, all the problems that come with that, with the root system and everything else. All of those things come together. You have to use common sense too.
Right.
When you see something that could be a problem, like that 100-foot sycamore tree that was 25 feet away from a wall, but if you take a look at it, you look at the outside of the house, you see no 45-degree angles at any of the windows showing stresses going from any direction. All you have to say is that this is present, it has roots, I cannot look at the roots. I would have a
structural engineer.
No. I would have to have a tree specialist come out, and I would have
that too.
Right. The whole thing. In other words, common sense is sometimes your best tool. If you smell something in a house, if you have hardwood floors throughout the house and you look at them and they're all pristine, the question is, were they just redone? I'll give you on the same Sacramento house that I just talked about. There was a situation in which the owner of the house, the person buying it, there was a crawl space inside a closet that could not have been 18 inches by 18 inches. And of course, the young home inspector could easily get through this. The buyer was a little chubbier, but he allowed the chubby buyer to crawl the space with him. You cannot allow that.
One time I did that.
Okay. And you have to say, the reason why I cannot allow you to be there is in case of emergency, one, and two, is my insurance doesn't cover it.
That's what they said.
The environmental, making sure, I'm still to this very day getting damages for termite inclusion all the time. And you point out the environmental. This one's a good one. When it talks about the provisions of the inspection report, there's no warranties. Again, that's there. When you have a situation that provides, and again, here is the number one major thing you have to have, and it's the one that says this is a 1-year statute of limitations. Now, the reason why it was thrown out for years was you never indicated the consideration. Remember, offer, acceptance, consideration. A written contract is 4 years. Where is the consideration that you give to the buyer? So he gives up the 4 years and takes 1 year. And the answer is, you put it in big bold letters, and it says, this time is shorter than otherwise provided by law, and client agrees as a material term and condition to this agreement, it should say contract, to be bound by that condition. What that is basically saying to you is that the cost of the inspection would be far more expensive if you took the 4 years. It's not saying you can't have the 4 years. It's a negotiated thing. If they want 4 years, you charge them 4 times as much. They don't want that. As it relates to liquidated damage clauses, that obviously you have to have, and that makes sense. But the biggest thing which I'm pushing every single person in CREIA is you do not have a contract that does not say where it is to be arbitrated, binding arbitration. And the only one that makes sense, and I have investigated every single one of them, what you want is a group that makes it mandatory that the person adjudicating it must follow the terms and conditions of the contract. The only one that does it is a national company called
Construction Defect Resolution.
Right. Yep. Construction Defect Resolution Service.
CDRS.
Right.
Yep.
And so you know that Tree Case had it. I'd never heard of them before. So that was about 5 years ago. I have pushed them ever since, and they have one rule. If, in fact, you have a contract, the person who arbitrates this must follow the terms and conditions. The liquidated damage clause that says you get your money back and nothing more, they must, I don't care if it's a $100,000 loss. He can only say you get that because that is the contract you signed. It is not important. It is muy importante times a million.
Muy importante times a million.
Now, one thing that most of these inspectors have no idea what to do, and even experienced ones, is what happens when you have a reinspection?
That's a very good topic.
And I have a copy that I wrote of a reinspection contract.
How come you never sent that to me?
Well, it's because you never asked for it, so here it is. The key to a reinspection contract is really very simple. In order to have a reinspection, you see it right at the front, turn it the other way. I use paper.
Got
My
it.
kids got me on that.
Okay.
Here we go. Gosh, it's amazing how animalistic they are. You have to use paper. Whatever. Anyway, the key to all of this is, in order to do a reinspection, you agree to do it. You do it on an hourly basis. You set a time and a set amount.
Mm-hmm.
And from
Per hour.
Per hour.
Yep.
Okay, now. And the writing of the report. Step number 2 is they must tell you in advance exactly what conditions you are to inspect. Number 3 is they must give you a copy of the report they received. So you look at what they got, what areas there are, and you give them basically a price. And you must have the signed reinspection contract and an estimate of what it is paid before you leave your office. You do never leave your office without signed contract and being paid.
You don't have to tell this guy that.
I get this all the time. You are not in the collection business.
Right. No, we're not in the collection business. I try to tell the inspectors all the time, why are you letting somebody say they're going to pay you after you're done? You just spent 5 hours on a 4,000 square foot house.
The answer is,
and you just wasted your whole day. And now you're going to hope they're going to pay you? That's crazy. That's crazy.
We had a case with somebody who is a really good inspector. Hang
on, hold off on that story real quick.
Great.
I want to go back to this reinspection contract. So I don't like doing reinspections. Now, one thing you didn't mention is, do we have to supply them with a new report?
You supply a new report on those conditions they called out that you reinspected.
So just an email will suffice?
No. You want a report. You're paying you for the report. You took time away from what you do. You could have done another inspection and made more money. No, you give them a full bill, nothing else.
And it only covers what they requested.
Not what they requested, what they wrote down on a sheet of paper that they sent to you and said, I want the electrical, the framing, the roof, the foundation, whatever it is, they must write it down. And you say, the way you get this information is you go to the report I wrote and say, give me these. So they go through the systems you have. Mm-hmm. They use the same form that you have. Everything is done the same way. Everything is generic to what you wrote. So let's take an example that could make it simple. Let's assume that you have a quasi-parapet wall, and there is a outside.
What the hell is a quasi-parapet wall?
Okay, it is a parapet wall, but it has almost like an outer area that goes over the side, like you would have a regular,
like our little roof.
Yeah, like a roof.
Oh, got it. Okay.
Like a curtain or an apron going around.
Got it.
And it would also have guttering systems. And this one, it's 35 feet above the ground, and supposedly it's on a tile roof, but it does have a parapet side to it. And you had to go to the very end, step over the curtain apron to look inside the grate to look at it. And they expected the inspector to do that 30 feet up off the ground. No, I'm serious. They did.
I believe that.
Yeah, okay.
Yeah, I believe you. That's crazy. So now, the reason why you brought that up is because why?
Because that was one of the issues that came up in a reinspection.
They wanted him to go up 30 feet and skydive.
Basically, they wanted him to go back and relook at it after the close of escrow in a in essence, reinspection, because somebody else came up there and they did do it, but he was a roofer.
Got it. So he did he decline the reinspection?
He was a little more direct than
that. He was a little more direct than that.
Mm-hmm.
He
suggested that he will go up with the owner, and if the owner leads him over the edge and walks with him, he will follow on the parapet wall side with him. but he's has to go over. The owner didn't take it well.
Yeah, got it. So that turned into a claim.
Mm-hmm. I don't have the claim. It was given to somebody else.
Meritless claim, obviously, because the roofer took a look at it, didn't he?
After the close of escrow, when it leaked.
Oh, got it.
And there were massive leaks. Massive.
So I'm sure in his report, he told him, hey, look, I can't look at this area because it's not accessible.
Yes, that's exactly what he said. He said, This is the area I inspected. And he said that this was not, he didn't feel safe.
Right.
But he knew it.
Right. Okay, so is there a problem with having a cancellation policy in a contract?
Be more specific.
Well, if someone's hiring me, they're reserving my time. So if they say, hey, John, I'd like to hire you for Thursday and today's Monday. I'm like, okay, great. What time do you want me to be there? 9 a.m. Okay, great. So that means from between 9 to 1, I can't take another job. So we're entering into a contract because now that they've called and requested that day and time, I then send them the inspection contract and the payment link, and they take care of all that. So now we're confirmed that I've reserved my time for them on that particular date and time. And then
the day before they decide they don't want the house.
Whatever, yeah.
Okay. The bottom line of is you can put a cancellation, but it must be within a reasonable amount. So in other words, let's assume the fact that you have an inspection for $800,
Mm-hmm.
a canceling fee, 24 hours, and they have to give you at least 24 hours. Okay. And if it's not, there's a charge of $200 or something like that. But you will find that type of thing will really cut into the amount of business you get substantially. It's sometimes better just to use that additional time to get a report out or something like that. And the other thing we haven't talked about is the cutting edge software. You've got to have the cutting edge. You've got to have the best software that really is right on top of it.
So you mean Spectora software?
Well, whatever one.
That's what I use.
Okay, you use what?
Spectora.
I have not seen that one, but
I'll send you a link.
Okay, all right. I'll be happy to look at it.
Yeah, take a look. Yeah, I think you'd be impressed.
Okay,
it's got a lot of good bells and whistles on it.
But it's got to have within your standards of practice.
Sure.
Okay, right.
No. Everything that is in my software is everything I put into my software.
Okay.
So any contracts all come from me, not them.
Okay.
So I just add what I want my customers to receive, and they get it.
What you haven't talked about is getting new insurance.
What's that?
Getting new insurance every year.
New insurance?
Yes.
Okay, go for it.
The bottom line of it is that your best results are based upon when you do get a claim and how you get out of it. I would ask them, who do you use in this area, and et cetera. And if you don't like the firms, you say, no, our chapter uses this person. He lectures all the time, blah, 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 blah. Some insurance companies will do it. Some insurance companies won't. So there's an insurance company called, I can't think of the name right now. It is Scottsdale. National does all the rep work for Scottsdale. They do all the adjusted work. They do not allow, for an example, let's assume you're being deposed and you're deposed on a case and you need to stop and you need to review your file to make sure you're ready. They don't pay an attorney to review. So in essence, an attorney, no matter how many cases, must know every single fact, every single event, when it was. Already, you cannot review your file for anything because they won't pay for it. They also classify everything on a computer program of what would be the reasonable charge for that. Now, remember, we have how many states, how many jurisdictions, how many sub-jurisdictions, how many special rules. They think that everyone should be combined and divided by that number. So in Alaska, where they don't have many claims at all, that's all included. So all of a sudden, if someone bills out hypothetically $200 an hour, which is a joke nowadays, but that's what they pay, $200 an hour, and you are filing a motion for summary judgment, in order to write that summary judgment, you must review all the evidence and put it in the right place. They don't pay you for that. If you have a phone call from someone, it goes into a zone of you called this person with their classification. Everything goes into a computer. Then they have a computer company that says, is this reasonable or is this not? And these people are non-lawyers. They don't know the case. Oh, yes. It's a joke. I've just eliminated one insurance company. I said, I'm not going to do it.
Wow. Are you familiar with Inspector Pro Insurance?
I am not. I've never had it in one of their cases.
Check them out. I'll send you some information on them. I just had one of their guests on, like I mentioned in the previous podcast, and I learned a lot from it, and I got some good information, and it sounds to me like they're trying to be very proactive with their home inspectors to avoid claims, and they're really, really big on risk management. and they really put it out there constantly.
Well, again, because the defense business is so hurting right now, everybody's getting into it. Mm. So again, the only way I would get into it is if somebody called them and said, our chapter or Los Angeles County or the Los Angeles Ventura County uses as their expert lawyer this person who's been doing it, and he writes our standards of practice.
I'm going to recommend you. I'm going to recommend you because I don't think they know who you are. So they're out of Utah, I believe.
Okay. Well, again, I lectured at the AII convention in Utah.
Oh, you did?
Yeah, for the home inspection industry from Oregon, Washington, Idaho, Nevada. It was one of the ones was there.
So, Greg, I feel pretty good about what we talked about, and I think we covered a lot. Anything else you wanted to add?
Yes. There's a famous expression that says, if I give my heart to you, I'd have none and you'd have two. That's the only way we're going to win this battle is to organize inside. There's a palace revolt going on upstairs. Yeah. It's pretty ugly. And the company that's been running it is going to be thrown out. Mm-hmm. They barred 2 people from voting on something, claiming they weren't authorized, including the president and one of the board members that ran a chapter. Mm-hmm. I've been following this. The inmates are running the asylum. Look, this is. I'll give you another.
I'm not surprised. I'm not surprised.
I know, but all we have to do is organize it for them.
Yeah.
And it takes. Look, I'm supposed to do a contract one with Volmar Keith, the president of CREIA, and for all of the home inspection contracts and stuff, they allowed me 1 hour and 30 minutes counting an introduction and all questions.
That's not long enough. We just sat here. We're at 1 hour and 50 minutes already.
Yeah.
So let's end it here.
Great.
I wanted to ask you, can home inspectors contact you to hire you?
Absolutely.
Do you have a set contract fee, or you just have to go by what it is?
No, I have to go by looking at what it was. They may have something that is so minuscule. Well, look, I get calls all the time saying, Greg, could you just write a letter on this? And I write a letter and it goes away and I'll charge.
How do you want to be reached?
Just at my cell number or the office number.
Okay. So I'll put those in the podcast description so everybody can find you.
Well, I'll just give it to you now. It's the office number. It goes directly to an answering machine because we're going virtual. So it is 818-433-3666, and my cell number is 805-207-4888. But we're still virtual right now.
Okay.
And
so a robot's going to answer the phone.
No, it's an actual person that does it. I know, but the robots do it, and
right.
When I called up one day and I got a robot, I said, no, I need a person. I want an IQ there somewhere above 1. So anyway.
Sure. I want to thank you for coming on the show.
Sure.
I've been trying to get you on here for a while, but I just had to get my
topics
together.
This is I love the setup. I mean, this is
my new setup.
This is fun.
This is my new setup. I had a very uncomfortable setup in the beginning because I was just getting into it, and I had people over that I could tell they were uncomfortable. I'm like, oh, I feel bad. So I just
set this up. Yeah.
I took everything out of this office and I just redid everything, bought a whole new desk, nice, comfortable chairs. I love it. We're just far enough apart. Yeah. It's great in here.
The technology is really good.
Yeah. By the way, I started my podcast from the advice of an actual client. One day he goes, John, you need a podcast. And his name's Matt Neal. And he just gave me some advice. And then we had a little FaceTime. I'm sorry, not FaceTime, Zoom, Zoom, like 30-minute Zoom meeting. And he kind of was explaining to me, he goes, you got a lot of good information here. You need to share this. Great. So that's how I get started.
Well, you got all the tools and stuff.
Yeah, he showed me. He gave me some good pointers on what to buy, and then I kind of figured out the rest. So that's good stuff. Thanks for listening, everybody. Thanks for watching. Greg, say bye.
Say goodbye.
Yeah, that's your famous ending. Okay, John, say goodbye.
Say goodbye.
He always tells me to say goodbye when he's on the phone. Say goodbye. But anyway, that's it for me, John here from the Home Inspection Authority, and thank you once again, Greg Pyfrom, the attorney for the home inspectors. If you need an attorney, call Greg. He knows what's up.
I know all what's up.
Yes.
And of course, then again, I'm modest and I'm just low key and just lovable.
That's it.
All right. Talk to you later.
Okay, just a friendly reminder. If you're buying a home, don't panic. Home Inspection Authority's got you covered. You can schedule us online by going to homeinspectionauthority.com 24/7, or you can call us at 800-950-8184. We offer general home inspections, mold inspections and testing, sewer camera inspections, indoor air quality testing, swimming pool and spa inspections, and light commercial inspections. We use specialized tools to provide the most thorough inspection possible, such as drone for roof inspections that are not accessible, crawlbot for under homes and tight crawl spaces to get to those areas otherwise not accessible, and we use thermal imaging technology as well. So give us a call at 800-950-8184. Or like I said, you can schedule online at homeinspectionauthority.com 24/7.